Russian author Fyodor Dostoevsky said you can judge a society by how well it treats its prisoners. Indian statesman Mahatma Gandhi said, "A nation's greatness is measured by how it treats its weakest members." English statesman Winston Churchill said that you can measure the degree of civilization of a society by how it treats its weakest members. While it's perhaps difficult to disagree with these statements on a purely philosophical level, the practical world does not operate on philosophy alone, because while philosophies state broad and idealistic principles, the real world must deal with down and dirty, nitty gritty of life. In the context of capital punishment, the first question is whether to embrace the construct at all. Many societies have abolished the practice. After declaring the capital punishment laws of all states unconstitutional as written in 1972, the U.S. Supreme Court left the door open for any state wishing to do so to reinstitute capital punishment by constructing a statute that would meet the constitutional principles set forth by the Supreme Court in that case. As a result, 32 states have returned to capital punishment over the years since 1972. For states that embrace the idea of capital punishment today, there's a second question. Are there persons convicted of capital crimes who nonetheless should not be put to death for some reason having nothing to do with the actual crime of the person committed, such as, for example, mental illness? At base, the answer to both of these questions has to do with how each person sees the world in moral terms. Clearly, the majority of U.S. citizens favor the death penalty. It is axiomatic that those who oppose capital punishment altogether also oppose capital punishment for anyone who is mentally ill. The third and most important question in this discussion is how to define mental illness in the context of capital punishment. The legal question concerns how to treat mental illness such that it will not conflict with the Eighth Amendment to the U.S. Constitution, which bans cruel and unusual punishment. In March 2017, the U.S. Supreme Court, in the case of Moore v. Texas, set aside a death sentence for a man who at age 20 murdered a store clerk in a botched 1980 robbery, based on the court's view that since the convict had been deemed mentally ill at age 13, the death penalty was unavailable. In 1973, Moore had been found to be mentally ill because he could not tell time, name the days of the week, name the months, name the seasons of the year, or comprehend the standards of measure. In deciding this issue in the lower courts, the Texas Court of Criminal Appeals had indicated that because Moore had demonstrated adaptive strength by living on the street as a teenager and by committing an armed robbery, he did not qualify as having the type of severe mental impairment that would make his execution cruel and unusual under the Eighth Amendment. However, the five-justice U.S. Supreme Court majority ruled that the Texas court had relied on an outdated understanding of mental disability and ordered the court to reconsider its decision. The three dissenting judges agreed that the lower court may have used outdated standards, but said that Moore's IQ scores, ranging from 59 to 78, showed that his intellectual functioning was not sub-average to the degree that he should be exempted from the death penalty. So, what are the proper standards to be used? In 2002, the Supreme Court barred the execution of persons who had been determined to be mentally retarded as violating the Eighth Amendment. But it left the states some freedom to define the parameters of mental retardation in this context. In 2014, however, the Supreme Court, after having overturned a number of such cases decided by the states after 2002, told the states that the IQ test that they were using to determine retardation was outmoded and that they must use data that was adjusted for standard statistical errors and that state standards must follow the medical community's diagnostic framework. The High Court ruled in the recent Texas case that it had used neither of the proper assessment methods. Essentially, the case was remanded to allow Texas to use the proper standards in reconsidering the case. It should be noted that regardless of the methods used for determining mental illness in the capital punishment context, there will always be hordes of organizations opposed to capital punishment in general, and therefore opposed to any mentally impaired persons being executed. All this said, it may be that the issue of mental illness in relation to capital punishment is becoming less important, because even as voters continue to approve of the idea of capital punishment, capital punishment cases are on the decline. In 2016, only 30 people convicted in capital cases were sentenced to death, and just 20 were actually executed, the lowest number in decades. Capital sentences and executions have been declining steadily since the 1990s. So while the majority of Americans still favor capital punishment, juries are becoming less inclined to mete out that punishment. Still, the mental illness and capital punishment issue persists as society continues to search for its correctness in a difficult world.